Hi, this is Kelsey Fukowski for AP Gov Review, and in Unit 4, Part 3, we'll be continuing our discussion on the judicial branch. In particular, we're going to be looking at the selection of Supreme Court justices to the U.S. Supreme Court. What's very interesting is that the Constitution is extremely silent on their qualifications. Remember that Article 3 of the U.S. Constitution only states that justices have to be in good behavior, and what constitutes good behavior is very unclear. Hypothetically speaking, you could have your 2-year-old sister become a Supreme Court justice. Hypothetically speaking, you could have the dictator of North Korea, Kim Jong-un, become the next Supreme Court justice. Now, of course, that's never going to happen because you have some checks over that. Of course, the president is responsible for nominating federal judges, and more importantly, too, the Senate must confirm them. So if the president, had some type of illness, mental illness, and selected some ridiculous candidate to become the next court justice, of course, the Senate would never confirm that selection. So you do have some checks there. Of course, that is a major check on the president by the U.S. Senate. Now, when the president is going to select somebody, of course, the president has to be mindful, can it get confirmed by the Senate? And you're also going to take input from the Department of Justice, the FBI, members of Congress, the sitting judges, and of course, the Bar Association. So a number of different factors playing influences here on the president's selection. Also keep in mind here where you have, of course, an elephant or a donkey. While the Supreme Court was supposed to, of course, be the least political branch, according to Hamilton's Federalist Paper number 78, of course, that political influence is going to play a major role as to who's going to get selected. So let's first start off with lower courts, right? We're not talking about the Supreme Court here. We're talking about district courts, and we're also talking about the courts of appeal. So the lower courts are something called senatorial courtesy, where the Senate will not confirm a district court judge if the senior senator from that state where the court is located objects. So typically the president is going to confer with the senators from that state ahead of time due to the confirmation process. And again, dealing with senatorial courtesy, if that federal judge is in conflict with that particular senator or that senator does not like that particular district court judge, typically you'll see senatorial courtesy play out. Now, president, of course, has more influence in the appellate court system. The appellates, of course, are important because they are now going to be involved in setting precedents for the lower federal district courts. Now, when we're talking about the Supreme Court, as president, you're going to typically appoint a justice who represents the president's own political philosophy. So if you are a liberal president, you obviously are not going to select a justice that's going to be conservative. Remember that when you're selecting a judge, a justice, they're serving for life. So you're talking beyond one's 4 or 8 years in office. You could be talking 20, 30 years potentially. So this is going to make a very lasting impact, especially when we're talking about the policy-making role that the Supreme Court is going to have. Now, no president, of course, can make all appointments. Federal judges do serve for life, again, to insulate them from politics. But to give you an example, under Nixon's administration and his brief tenure, he nominated 4 justices, whereas Carter, sadly, 0. So again, it really depends on whether the justices are going to stay around, if they might pass away, might they retire. So these are all important things. So after the president is going to nominate a justice, certainly you have the Senate's role in confirming that justice. Confirmation is a formality for most of the federal district courts, but the appeals, and especially the Supreme Court, much, much more rigorous. And that's where the Senate Judiciary Committee is going to play a major role. They are going to interview the nominee. They're going to hold these hearings that you might see on television before it goes to the full Senate for a confirmation vote. If the committee is going to reject the nominee, the Senate is usually going to do the same. In 2008, interestingly enough, 28 out of 148 individuals nominated to the Supreme Court justices were not confirmed. So there you see it there. So again, not everyone gets through. So as a president, some of your criteria, of course, political ideology is going to be important. Party and personal loyalties. 90% of judicial appointments are members of the president's party. You do not see a lot of reaching across the aisle because, again, judges play a major role, especially in the Court of Appeals and the Supreme Court with its policy-making function. Now, there is also, of course, the acceptability to the Senate. Will the Senate confirm that particular justice? Judicial experience. Probably want to hold some judicial position. There have been some presidents, such as Bill Clinton, who was thinking about nominating somebody who really had no political experience, or judicial experience rather, only had political experience. So again, remember Article 3 is silent as to what the qualifications are for a Supreme Court justice, but nevertheless, that can play a role. Also, race and gender. Before 1967, all were white males, and we've seen diversity, especially amongst women, steadily increasing. And some presidents, although they might deny it, have a litmus test, really sort of a test of ideological purity, such as attitudes towards abortion rights, which is very important, especially for conservatives and Republicans, as well as civil liberties, especially as we saw this after 9/11. So if, let's say, you're a conservative president and the justice has a history or record of, ruling for abortion rights, typically that's not going to be the justice that's going to be nominated. Okay. So let's go back here to the structure of the federal judicial system. So the Supreme Court ensures uniformity in interpreting national laws, resolves conflicts among states, maintains national supremacy and law. They are the Supreme Court. They are the highest court of the land. There, of course, are 9 justices, 1 Chief Justice, and 8 Associate Justices. Supreme Court, interestingly enough, basically controls its own agenda. It decides which cases it will hear. Also, the acceptance to the bar is not required, which the bar basically authenticates you as a lawyer, which would then sort of authenticate you as a judge. But nevertheless, you do not need to be accepted by the bar. Just appoint and approve them, and job is secure for life, as we know. They do have some original jurisdiction, but most of it is going to be appellate jurisdiction, so they're going to be hearing cases that were heard most likely at the district court level. Some cases come from the federal courts. Most are going to be involving civil cases, not criminal cases, so that's important to note. So here we see the structure of the federal judicial system once again, and you see the Supreme Court on top. So the politics of judicial selection. Typically fewer constraints on the president to nominate persons to the Supreme Court, unlike the lower courts. President does rely on the Attorney General, as we talked about, as well as the DOJ, the Department of Justice, to screen candidates. About 20% will not make it through the confirmation process. The presidents with minority support in the Senate will have much more difficulty. That is important to note. And the Chief Justice can be chosen from a sitting justice or as a brand new member to the court, as we saw after Chief Rehnquist's death, leading to Chief Roberts' nomination as the Supreme Court Chief Justice, which he now serves. Interestingly enough, their sessions are only from October to June, so a lot of their calendar is not necessarily spent working. But there have been unsuccessful Supreme Court nominees since 1900, so, looking at under President Hoover, 1930, Parker failing, you have Harriet Miers, another notable person who was not accepted as a Supreme Court justice. So certainly this is nothing new, and this has happened many, many times. So characteristics, again, generally speaking, white males, lawyers with judicial and typically often political experience. Other factors involve being of the same political party and ideology as the appointing president. And of course, judges and justices may not rule the way presidents had hoped they would have. A good example with Eisenhower with the Warren Court, as we'll look at in Unit 6, dealing with civil rights and liberties. So sometimes you might think that the Supreme Court justice that you're putting into the court is going to always rule the way you hope. But typically, sometimes, I shouldn't say typically, but sometimes you see that justice going the other way. So it's never really a slam dunk. And here's a picture of Sonia Sotomayor answering questions before the Senate Judiciary Committee right before she became a U.S. Supreme Court justice, so getting grilled, so to speak. But it can be very successful for several. So here are some of the backgrounds of judges and justices. Again, this looking at being on the Court of Appeals definitely certainly helps in getting a profile out to become eventually a U.S. Supreme Court justice. So you see just the background here certainly helps. All right, so the jurisdiction of the federal courts, as we've said in other videos, certainly has to involve a federal question or constitutional matter. So case concerning the Constitution, federal laws, treaties, that automatically is going to become federal court case. And diversity cases, certainly involving citizens of different states. And then also you have what's called a writ of cert. This is an order by a higher court being mainly used with the U.S. Supreme Court, directing a lower court to send up a case for review. So most of the cases that the Supreme Court is going to hear come from a writ of cert. They get a lot of petitions, the Supreme Court, to hear many cases, but again, they only run from October to June, so you only have a limited amount of time to hear cases. So they're all going to allow only a certain number, sometimes between 80 and 100. So that's not that many with respect to the thousands of cases that they are petitioned to hear. So ultimately, accepting cases, what happens is the Supreme Court, remember there are 9 on the bench, they use the rule of 4 to choose cases. So all that means is only 4 sitting justices have to agree, and that becomes a U.S. Supreme Court. So once they get the rule of 4, they will issue a writ of cert, which in Latin means made more certain, and it's going to call up that case. So that's going to be very important. So it really, when you see a court be issued, or the court issuing a writ of cert, it really takes a while for that to happen. So again, the court case originally in federal or state court is going to have to request for the Supreme Court review, and it can be as many as 8,000, even exceeding that. And appeals discussed in conference amongst the justices, and about 99% of these cases are going to be denied. Once it obtains 4 votes, it is then placed on the docket. Again, typically fewer than 100 cases, so not many cases heard at all. And again, very few cases that you see. So for example, on this chart here, number of cases filed, again, does vary, but just a very small number that are going to be heard. And you sort of see a little bit of a trend here that since around the 1970s, it's actually dwindled from 158 cases down to a mere 82 between 2009 and 2010. All right, so let's end with a review question. Presidents have had the most success in changing the direction of decisions of the federal judiciary by doing which of the following? Take a moment, pause your screen. All right, and if you said choice D, using the appointment process to select judges with judicial philosophies similar to those of the present, that would be correct. That is the best way to really change the direction of decisions, because you want somebody of the same political persuasion as yourself, and that ultimately is going to be the most successful way of doing so.